welcome to the show once again. We'll begin with the fallout between Nigeria's Attorney General and the Judiciary. Attorney General and Minister of Justice Abubakar Malami has denied blaming the Judiciary for a perceived failure in the dispensation of justice. He was responding to the Judiciary's rebuttal of statements credited to him over delays in the trial and delivery of judgment on corruption cases involving politically exposed individuals. Malami says he was misconstrued by some mischief makers who projected him as blaming the Judiciary in his response to a question during an interview with journalists. According to him, government has acted only within constitutional mandate on its roles and responsibilities. The Supreme Court had described Malami's position as one-sided. It said, although the Nigerian judiciary does not claim to be perfect, when the political and economic conditions under which it is operating is compared with its counterparts in other climes, it will be adjudged a prize model. Well, for more on this, I have Arise Judiciary Editor and Deputy Director of News, Tobi Soniyi. Glad to have you, Tobi.
Yeah, thank you, Samna.
And let's start with this rebuttal by the Attorney General of the Federation. You think that that statement from the Judiciary was too hot for him to handle and he had to recant? I mean, because we actually see Malami stating critically that they take cases to court, and unfortunately the federal government is unable to come to a conclusion of some high-profile cases of politically exposed persons because the Judiciary seems to be slow and not giving the government the leverage to be able to say that they've been able to prosecute more politically exposed persons. What do you think he was trying to aim at with this reply?
Yeah, well, let me take this approach. I believe there is no blame to go around, whether for the judiciary, for the executive. All of them have their share of blames to take in the delay of trial in Nigerian court. And if I have the time, I want to explain what I mean by that. Yeah, for instance, in Nigeria, the judges still write in longhand, and this makes the trial to take so much time.
Yeah, in this
it wastes so much time. I mean,
electronic technology.
Absolutely. So they cannot blame the executive for that. The judiciary has itself to blame. So to some extent, there is some truth in what the AGF is saying. I don't know why he's recanting anyway. But then, the judiciary alone cannot be blamed for the slow pace of justice delivery in Nigeria.
But you have, for example, the case of the former governor of Plateau State, Senator Jonah Jang, which as at yesterday we read that the case was starting afresh because a judge had retired. The previous judge who was handling the case had retired. Now, this is a politically exposed person. This trial started in 2018. Why would we have that case starting afresh just because a judge has retired? Isn't that one of the things that the Attorney General is actually pointing at? Yeah,
that blame will go to the judiciary straight away. If the judiciary is aware, the head of court, the chief judge of the court, the Plateau, High Court where it's been tried, if he's aware that the judge is going to retire in the next 1 or 2 years, there is no point assigning such a case to him. Otherwise, they just change the system, because the law is that a new judge, another trial will have to start if a new judge is assigned the case. We call it trial de novo. They start afresh. So, I wouldn't know whether it's deliberately or it's an oversight on the part of the chief judge of that court to have assigned the case to someone who is going to retire soon.
Yeah, I mean, there have been those allegations every now and then where we hear that politicians are influencing the court processes in one way or the other, and it's been a very sad development, because you would wonder why, for example, a judge who is said to be retired in 2 or 3 years is being given those cases like you've talked about. Look at the case of Oju Zokalu. After several years, I mean, he left government since 2007. That case has not come to a conclusive end. He was sent to Kuje prison, but eventually that case went up onto Supreme Court, and then EFCC says it's starting the trial afresh. That one, isn't it the blame of the executive, because the EFCC is under the executive?
Well, I think both parties will have to take their own share of the blame. The judiciary, there's another group we also need to have, the lawyers. Sometimes they deliberately bring frivolous applications that the judge, under the rule of court, is bound to take them. And in the process of taking these preliminary applications, 2-3 years, it's gone already. And therefore, the judge is duty bound to take those applications. So the lawyer is deliberately frustrating the trial. He's trying to buy time for his client. There is nothing more even the prosecutor can do. He still have to allow the defense to have his own time. So I'm widening the net now. The bench, the back, even the executives, all of them have their own share of the blame. If we must reduce the time it takes to dispense with cases, I think all the party will have to sit down.
And now let's talk about the role of the Nigerian Bar Association in the speedy dispensation of justice. Do you think the NBA has a critical role to play in trying to see how the Administration of Criminal Justice Act is fully obeyed without, delay in court cases and all of that?
Yeah, absolutely. Lawyers have a great role to play to make sure that the law takes effect, and the Administration of Criminal Justice Act is fully implemented. They say you cannot clap with one hand. The judge alone cannot do that. The lawyers who is defending his client, we're all lawyers are justice, what do they call it, in the temple of justice. We are here to help the court to arrive at the justice of the case. But the truth is that most lawyers are in the court to frustrate proceedings, and
especially in politically exposed cases.
Yeah, because they have the funds to pay, they have the money to pay, and therefore they are able to get the best of lawyers. So they start wasting time on, like the CGN said too, even the prosecutor, the EFCC, ICPC, they too have to take the hint.
Yeah, he was saying that the federal government files more charges than it can prove in court, while describing the minister's position as one-sided. How do you think this can be given more strength? Because we've seen cases where the EFCC keeps losing and losing and losing cases. In fact, there was a time that it became so embarrassing, and people had to be questioning why we have a vice president who is a professor of law, and yet the EFCC is unable to put its acts together. The federal government keeps losing cases in court.
The truth is that those anti-graft agencies, they play to the gallery. Sometimes, if it's only 3 charges you can prove, why filing 50 charges? Why filing 50 count charges? And if somebody is willing to do plea bargain, like I was reading from the Judiciary case, the former registrar of JAM. If he's ready to do plea bargain, why don't we jump at this? And
some Nigerians have also criticized the plea bargain, saying it works more for the elites rather than for the benefits of Nigerians.
But at least, even if it's 1 year that is sentenced, up to today, Kalu has not been sentenced into a 1-day imprisonment, and is likely to get away with it. But if Judiciary wants to go and do 3 years, well, at least he remains an ex-convict. So we are making some progress. So for me, I think the prosecutor should also be mindful of the process of court, try to reduce the charges, go to the one that you can prove, and that the man cannot escape, as is done in the US. Once they bring the charges before you in the US, you surrender, because you know there is nowhere to hide. Your lawyer will advise you that, look, if you waste the time of the court, you are likely to get more years.
Punishment.
So it's in your own interest to agree at this level, and the system works for everybody.
All right, just hold on there. Tobi Soniyi, Arise Judiciary editor, as we go on this short break. When we come back, we'll continue the conversation. Welcome back to the Arise interview. I'm Samna Sambo, and we've been speaking on the ongoing spat between the Judiciary and the Attorney General of the Federation and Minister of Justice, Abubakar Malami, on issues within the purview of the dispensation of justice in the country. And still with me in the studio is Arise Judiciary editor and Deputy Director of News, Tobi Soniyi. And Tobi, I come to you. This is not the first time that the Attorney General is hitting at the Judiciary. Just 2 weeks ago at the NBA conference, he actually made mention about the opacity of the Judiciary when it comes to distribution of funds. I remember where he was saying that about 104 billion naira that was appropriated for the Judiciary, he doesn't know what, the federal government doesn't know what the Judiciary does with it. That how can they, let me just quote him. He said, why is the 104 billion naira provided for the Judiciary in the budget insufficient? He says, we are not in a position to answer because that is the judiciary's books are not open. He disclosed this, saying that it's important for the judiciary to be open about the way it goes about, spending the funds allocated to it. And just later on, 2 weeks later, we are seeing him hitting back at the judiciary, saying that they are not helping in the quick dispensation of justice. What do you think about all of that?
Well, on the first allegation, judiciary is not open. I think it's self-indicting for him. For me, it's an own go. EFCC has the power to open books of any agency, whether it's the judiciary, it's National Judicial Council, the Federal Judicial Service Commission. Has EFCC gone there and was denying access to the document? If the answer is yes, then we will know what to do. The answer is no. EFCC has not gone to investigate any fraud there that they say, no, you cannot come here. So the EFCC is controlled by the executive. If the executive is not doing his job, he cannot blame judiciary for not.
And that's why the judiciary, sorry to cut him, was actually saying, while trying to hit back at Malami, that they don't control the forces of coercion or investigation. Absolutely. And all of that. They don't control that by the nature of that institution. It's just an institution focusing on justice, on the dispensing of justice and all of that. Yeah. Now, Malami was trying to say that there needs to be an open government partnership arrangement. We can never be in a position to identify to what extent the budgetary provision made for the judiciary is inadequate when the judiciary doesn't open its books. Do you think that even the National Assembly in this tripartite arms of government has been open with its books?
Before we go to the National Assembly, has the Minister of Justice been open with his book?
Very interesting.
So do you know the account? I mean, how much was budgeted for the Ministry of Justice and how much was spent? So I think the question is neither here nor there.
Or even the executive. Haven't we seen the presidency, the State House budget being so huge that Nigerians are talking about it? And
Absolutely.
there does seems to be like accountability. How do you think there can be some partnership between these two critical arms of government, the judiciary and the executive at the moment, to reduce this tension that they have between the AGF and, of course, the Chief Justice?
On transparency, I also need to add that the Office of the Accountant General's open all books, and if they find anything with previous account, that is a bit reactive anyway. It's not proactive, but they can see 2020, 2021 account, and then if they find any fraud or whatever, they recommend to the appropriate agency. But for slow dispensation of justice, for me, I think both the judiciary and the bar, the lawyers, including the Attorney General himself, and the Ministry of Justice will need to come together in the interest of this country. There are a lot of investment that are going elsewhere because they don't trust the Nigerian judicial system. It takes too long. And that is why when in arbitration, some company will say, no, when it comes to dispute and arbitration happens, we'll go to UK. Because they know once you choose Nigeria as jurisdiction, you're going to get stuck. In the next 20 years,
is there corruption in the Nigerian judiciary?
Well, absolutely there is, but sometimes it's not just about corruption. It's about the system that is not helping itself. So we need to win more because sometimes it's not very open. They think it's only the job of the executive to bring investment to Nigeria. The judiciary has a lot to do with attracting investment to Nigeria. If they know you can get your case dispensed with within 2, 3, 6 months, well, it's good. And if they know the law is certain, they will come here. So we need to help ourselves. I mean, I will advise the CJN, it's not time to bicker. It's the time to sit down with the Attorney General and maybe the leadership of the Nigerian Bar Association and say, look, we all owe this country. How can we help ourselves? This idea of throwing blames is not helping anybody.
Yeah, I mean, a lot of Nigerians will actually wonder why there's a breakdown of communication between the executive and the judiciary, because there were previous allegations that this government was influencing the judiciary, especially with the sack of the former Chief Justice of Nigeria. Absolutely. And then the appointment of this one. But why do you think there was that breakdown in communication between both? I mean,
this administration is gradually coming to an end. So everybody is beginning to move on anyway. So maybe the judiciary is moving on too.
Do you think Malami was trying to sound more political? Because I mean, there have been ambition. He's eyeing the governorship of Kebbi State. He's trying to win more political applause to himself, and so that's why he's going on this hard-hitting adventure, if you may call it that way.
I wouldn't read political meaning to it. For me, I think he has a point. It's just the way he presented it that I think is the problem. Nobody can deny the fact that, I mean, dispensation of justice is slow. Nobody can deny the fact that there is no corruption in the judiciary. But, you know, you don't just make a blanket statement. You need to go to the specific. If you have, I mean, if there is anything, there is a smoke somewhere, the anti-corruption agencies know what to do. It's not to be making political statement anyway. That is not how to help matter.
One of the critical things needed in judiciary is modernization in terms of ICT, employing information communications technology into it. How do we modernize our court system to actually ensure speedy dispensation of justice?
That is where the leadership of judiciary is failing itself. It took the arrival of the pandemic, the COVID-19 pandemic, to suddenly know that we can use Zoom to do trial. Otherwise, they will have argued against it, they will have told you why it will not work. But when it became practically impossible for lawyers to come to court, they resorted to using the Zoom. But do we have to wait till the pandemic happens? For instance, we've been crying loud and clear that our judges don't have to write themselves to death. We can save a lot of time. If you know the number of hours it takes a judge to write proceeding, you will understand why it takes so long to deliver judgment in a case.
And a lot of lawyers have also criticized the judiciary in terms of embracing this ICT, because during the pandemic, we actually saw court cases being held via Zoom and all of that. And immediately the COVID cleared and then the lockdown was open, the judiciary just went back instead of expanding this usage of Zoom and all of that. Why do you think that happened? Yeah,
change is very hard. It's difficult to embrace change. They refuse to embrace technology because I don't know if they're afraid of it. They refuse to stop writing in longhand. I don't know, maybe they don't know how to use iPad. They were not the one that would do the recording. Somebody would do the recording, and by the time the court rises, the proceedings will be on the table of each judge already, and the lawyer, it even gives room for correctness. This handwriting thing has its flaws. Sometimes what the judge says is not what, what the lawyer says is not what the judge properly recorded. We have had instances of that. But if it is recorded and it can be played back, there is no way the lawyer will say, this is what I say, and this is, the judge will report a different thing.
Well, most thank you so much. Arise Judicial Editor and Deputy Director of News, Tobi Soniyi, for joining us on the show to take a critical look at the spat between the Attorney General of the Federation and then the Chief Justice of the country.